So, in regards to the HPHCs that are due November 2019, um, there was a lawsuit that was filed, a lawsuit that was filed on December 13th, 2018. The Cigar Association of America had filed this to delay the November 2019 deadline for the HPHCs. Most likely, this will bleed over to vaping devices as well, even though the Cigar Association of America filed that it's in regards to premium cigars. It could very well affect AFFECT, affect vaping as well, and we may get a delay if the court's willing to side with the Cigar Association of America. This is well before FDA Commissioner Scott Gottlieb resigned, so this has nothing to do with that. This was filed back in December. So I want to read this, and it's very short. Just read it, and then I'll discuss it. So it's case number 1:16-CV-1, 01460-APM. It was filed on December 13th, 2018. The United States District Court for the District of Columbia, Cigar Association of America, plaintiffs versus the United States Food and Drug Administration. So this is the joint status report. And this has been, by the way, this has been going on for a while. A complaint has yet really, well, it has been filed, but it may be amended. This has been going on for a while, but this is just a joint status report. Anyway, pursuant to the court's August 16th, 2018 status conference and November 8th and December 4th, 2018 minute entries, the parties respectfully submit this joint status report, and that is what it means is that the FDA and the Cigar, Cigar Association of America. So the Cigar Association of America and the FDA get together and they figure out exactly how they're going to handle this with the court into the future, as far as motions and the timeline, basically. Anyway, so it says joint statement. At this time, the parties agree to further defer briefing of counts 1, 4, and 5 of the complaint in this case until January 14, 2019, at which time they propose submitting a further status report with respect to these claims. The parties set forth separate statements below. And this is the Cigar Association of America's statement. Plaintiff's statement. As noted at the August 16, 2018 status conference before the court, and in the November 1st, 2018 status report, plaintiffs are concerned about the impending November 8th, 2019 deadline for reporting of harmful and potentially harmful constituent, or HPHC, testing for all cigars and pipe tobacco. In the deeming rule itself, FDA promised guidance regarding HPHC reporting and a rule providing a methodology for HPHC testing both well in advance of the November 8th, 2019. That has not happened. According to the Unified Regulatory Agenda, and what a Unified Regulatory Agenda is, all the agencies, it mainly comes out of, it's mainly for the president is mainly like chairs this whole agenda. I mean, but it's all the agencies with all their regulations, proposals of regulations, or even final rules or whatever have you, they all collectively go into this unified regulatory agenda. All the agencies across the board, all the federal agencies. Okay, so anyway, according to the unified regulatory agenda, such a rule is not even in the agency's pipeline. And even if it were published today, it would not be early enough, as the November 8th, 2019 deadline is to report the results of testing thousands of cigar types, not to begin the testing itself. Moreover, the pendency of FDA's premium cigar docket may obviate the HPHC testing and reporting requirements for premium cigars, but that docket will not be completed prior to the deadline. And they're talking about these particular cases that are pending. An extension of the November 2019 deadline has been requested from FDA. Unless that extension is granted, plaintiffs will need to bring claims challenging the HPHC testing and reporting requirement in January 2019. Options include seeking to amend the complaint by consent or by motion, or filing a separate complaint before this court. So, I could look into it and see if the FDA actually responded to the Cigar Association of America in regards to this extension, but what I could tell by what I've been reading, it has not been extended. It says, with regard to the substantial equivalence and pre-market review process and the arbitrary failure to appropriately treat the category of the premium cigar challenged in counts 1, 4, and 5, plaintiffs continue to monitor regulatory developments and are considering either continuing to stay those claims with the court's permission or dismissing them without prejudice, assuming appropriate protections for future litigation are put in place by agreement with the government or through court order. Plaintiff associations will provide their respective views on the appropriate disposition of these claims in their January 14, 2019 status report. And once again, they'll revisit this. FDA will get together with the Cigar Association of America to work something out and go from there. And this is the FDA or the defendant statement. Defendants remain open to having the remaining claims in this case, that is, counts 1, 4, and 5 of the complaint, either further deferred or dismissed without prejudice as previously reported. So they're willing to defer it, meaning into the future, and speak about it with the court some other time, or have the complaint dismissed without prejudice, meaning that they can refile again in the future. It says defendants have not received a proposal for appropriate protections for those claims in the event of dismissal, or for potential proceedings on any other unpleaded claims, but will provide their views once plaintiffs determine how they wish to proceed. And that will happen in that January 14, 2019 status report. I could look into the, go to pacer.gov and look up this case, but I'm not really truly interested. But the idea is that they're attempting to delay the November 8th, 2019 HPHC requirements as far as submitting these particular constituent reports to the FDA. Now, this can very well affect vaping if the judge so deems it so. You could do a across-the-board kind of situation. If not, then it just applies to premium cigars and pipe tobacco, and then vaping manufacturers will still have to submit the HPHCs to the FDA. So we'll see how it goes. Usually what happens in these particular cases, especially because it's in the District of Columbia, therefore, of course, it affects Washington, D.C. or FDA in general, it can very well bleed over to the vaping industry as well. That's the reason why I did this video. And so it's dated December 13, 2018. And this guy is always on these cases in the United States Department of Justice in regards to FDA. He mainly does regulatory programs. And then this Michael Edney, he is the plaintiffs or the Cigar Association of America's attorneys out of Norton Rose and Fulbright, U.S. So that means they have this international law firm. And then another attorney as well, Adam Goodwin and Proctor. And they're the attorneys for Plaintiff Cigar Association of America. Be rather interesting. It'd be good if that's delayed, because no vaping manufacturer is going to be able to submit these HPHCs. It'd be the doom of the vaping industry anyway. Not that there's many other problems we have anyway, but And it is true. It says in the dimming rule itself, FDA promised guidance regarding HPHC reporting and a rule providing a methodology for HPHC testing, both well in advance of the November 8, 2019 deadline. This is where the whole lawsuit is hinged at, this whole thing here. And that is true. That is in the FDA final rule in regards to premium cigars, because cigars like machine-made cigars were already regulated with the Family Smoking Prevention Tobacco Control Act back in 2009. And the premium cigars were not. It was through the FDA final rule on May 10th of 2016 when the premium cigars were effectively, they were regulated from that time and thereafter, especially after August 8, 2016, as well as pipe tobacco. Pipe tobacco also was not in the Family Smoking Prevention Tobacco Control Act of 2009. Didn't come about until May 10, 2016, when pipe tobacco was regulated as well. And it is true in the deeming rule itself, meaning the FDA final rule, it was supposed to give guidance to the industry on how to provide these particular HPHCs and so forth up to date. I haven't read any revisions. I haven't seen any guidances coming out of the FDA as to how they're supposed to do it. So they certainly have a claim here. We'll see what happens. I'll try to keep up to date on a little bit, but it doesn't really matter because it may or may not affect vaping. Usually, these types of courts, United States District Court, will affect other areas of the other categories of tobacco because they're speaking specifically to the rule itself. So, if they find that the rule itself is in violation of the law, then it should ought to also affect everything else that's being regulated in that rule. And of course, everyone ought to know the FDA final rule is also regulating vaping. So it also ought to affect that as well. So they may very well have that delayed, and it could be delayed indefinitely until the FDA actually issues the guidance or the methodology as to how to do the HPHC testing. So, and that's why the FDA has no problem deferring it, because they probably don't want to really go down this avenue. Maybe they do, maybe they don't. Who knows? So far, they haven't issued anything on the FDA website in regards to a guidance as to how to do these HPHC testings. So anyway, I want to just share this with you. So, because it is a big deal. It is a big deal with in regards to vaping manufacturers. To complete these HPHCs, it's impossible. I mean, in other words, if you can complete an HPHC, you are probably about 7/10 closer to actually completing a PMTA or pre-market tobacco application. That's how difficult these HPHCs are. So if they could delay this, it'd be great. And until the FDA comes out with some kind of methodology, it could be delayed for quite a while. See what happens. But I just wanted to share this information with you. So there's a lot of people out there that are like, well, it's going to, Vaping Legion Network always brings it up. HPHCs in November of 2019 is going to be the doom of the vaping industry. Well, thankfully, the Cigar Association of America got off their dups and actually sued the FDA to delay the HPHCs. So you could thank the Cigar Association of America for doing so. And they have done a few things like this in the past that has rolled over to vaping as well, that affected vaping and helped us out. So, I mean, big tobacco has its own issues, has its own problems. And when they win in a court of law, normally, because especially premium cigars, I should say, premium cigars, if it affects the premium cigar, it most likely probably is going to affect vaping. So big tobacco in their own way, indirectly, of course, they're not thinking of us, but indirectly they help out help out the vaping industry as well. Anyway, let you guys go. I just want to share this with you. Guys, have a good one. Bye bye.